Number 115196, State of Kansas v. Christopher Schrader.
Good morning again, Your Honors. Assistant District Attorney Lance Gillette on behalf of the state of Kansas. For the benefit of the audience, briefly, Mr. Schrader was charged with involuntary manslaughter while driving under the influence. The charges stemmed from an incident that happened at a Wichita Dillon's parking lot where the defendant chose to operate his vehicle in a manner that resulted in him striking and killing a woman there in the parking lot. He subsequently entered a plea to that charge, and in his criminal history was a prior City of Wichita DUI conviction. There's a special rule that applies under Kansas law when someone is convicted of involuntary manslaughter while driving under the influence that allows a prior DUI to score as a person felony in that criminal history. That would then elevate the penalties that the defendant is eligible for. Here, that one prior DUI resulted in a criminal history category of D, referring to one prior person felony, and the district court sentenced the defendant accordingly. The issue in this case is very similar to the previous case that we were up here arguing about just a moment ago. The primary difference here, though, is the language of that special rule. And the state believes here that the plain language argument is actually the strongest of the two situations. The language here comes from KSA 2014 SUP 216811C2. And it is important to remember we are dealing with the 2014 supplement here because the language did change. But it allows the prior conviction to count as a person felony so long as it arose under an ordinance, quote, which prohibits the act described in KSA 8-1567, end quote. That language is incredibly broad. The act described in KSA 8-1567 is DUI. It, in fact, does not describe one act. It sets out at the very least five alternative acts under subsections A, 1, 2, 3, 4, and 5. And I believe it is referred to in the briefs, and the courts that have interpreted that have found that that they are actually alternative acts. You cannot possibly have a DUI in which all of those different elements are present at the same time. It's possible you could be convicted under two, but I don't believe it's possible that you could be convicted under all. I think it's also, again, so based on the plain language of this statute, the Wichita ordinance in question, the Wichita Municipal DUI Ordinance, absolutely prohibits the act described in KSA 8-1567. And as Justice Stiegel asked opposing counsel in Gensler, does that end the case? And yes, the state believes that should end the case here. The plain language of this statute is incredibly broad. If there were ever a need to delve into equitable arguments, in this case, I believe that the argument is, again, even stronger. Because here, what we're talking about is somebody that is engaged in behavior in the past involving alcohol and the operation of a vehicle that has jeopardized themselves or others. If they choose to do that again, and they take someone's life as a result of that choice, the legislature has seen fit to enhance the punishment. That's absolutely appropriate, because that's part of why we have DUI law in the first place, is if you're going to put yourself and others in jeopardy, we don't want you on the road. If you're going to continue to engage in that behavior and you kill someone, we don't just not want you in the road. We want to potentially put you in prison and keep you out of society. And so I think that the equitable arguments are even stronger in the current case.
Well, I guess the same question applies to Mr. Schrader. If the underlying conviction in the Wichita Municipal Court was for operating a human-powered via a bicycle under the influence, and that's his conviction. Is that an act that's described in 8-1567? Is it?
That act wouldn't be, but that's not the appropriate test. His conviction had to have arisen under an ordinance which prohibited the act. And here, the ordinance does. It does prohibit both. And that's all that the plain language of the special rule of statute requires.
Again, we get into the discussion of how far that can go, but
yes,
that's just basically your plain reading.
And again, I think it is a stronger argument here, given
Counsel, I'm not sure I understand that.
Okay.
What is it? Just the difference between prohibits any act versus prohibits the acts? Is that what you're relying on to say that the plain language argument is stronger in this instance?
I'm relying on where it says prohibits the acts that this section prohibits.
Right.
And the difference then in the special rule here is prohibits the act. Obviously, it drops the S,
right.
But it also refers to as described in the statute.
So it's prohibit the act versus prohibits the acts. Or I'm sorry, any act versus prohibits the acts.
Right, right.
And you're trying to suggest that the any act language is actually broader. That's how I understand.
I'm suggesting that the act described is broader.
Okay.
I want to again spend a little bit of time just on the Mathis issue, because I want it to be abundantly clear here that even if we do need to move beyond the statutory language that is at issue here, again, all that the state is asking this court, and all we've asked any court before to do, is to apply the Mathis test, apply the rules that we've been given by the United States Supreme Court. Those rules are the tools that we have to try to determine.
But that's dependent upon your condition, that what we're looking at is an element, alternative elements, or alternative, what we might call alternative means, but not facts.
Well,
we don't get to those tools unless we buy that this is divisible.
No. These tools help us determine whether or not it's divisible. They help us to determine whether or not it is an element or whether or not it is fact. Because if it is an element,
this is the peak language.
this is the look to state law and then the peak. Yes.
Yeah.
These are the two.
Which makes no sense to me, to be honest. I mean, do you really get it? I mean, what's a peak versus a look? I mean, I
think that the difference
like grade
here,
school.
the best that I can answer that question and is to say that what we're looking at is essentially we want to look at the charging document. We don't really care exactly what it says. We want to look and see how it's charged. Because if it's charged where they select one item to the exclusion of all others, or one element to the exclusion of all others, that is indicative of the fact that they consider it and treat it as an element, not as a factual question.
Okay.
And so the peak informs a legal analysis.
But originally, the purpose was to see what subsection. If you could, as opposing counsel says, subsection A, motorized vehicle, subsection B, human powered. You know, we've indicated those are one way to look at alternative means is or alternative elements, as you say, Mathis describes. And so we could look to see which subsection was charged, but charging documents include factual allegations. And what you want us to do is take a peek to see which factual allegations were being made by the prosecutor, rather than which subsection of the statute. And if your argument that vehicles is vehicles and that's the only element, then why do we even get the modified categorical? Because then it's a straight comparison, and is it broader?
Okay. I guess there are a number of questions rolled up there, and I need to respond
There are
to.
a number of questions here.
The first I'll take is, could the ordinance be more clear? Yeah, it really could. And fortunately for the state before you today, that's not the question that we have to deal with. Because our union is made up of 50 states. We have different laws, and we sometimes have to parse out what those laws mean when we start looking at criminal history. And it's okay to do that as long as we don't violate anyone's constitutional rights. The second point to get to is it is okay. It's okay to try to separate these things out because it is not necessarily a factual finding. And that is that's what Mathis tells us. I don't want the court to look at factual allegations. Can charging documents contain factual allegations? Yes. They also must contain the elemental allegations. And that's what we see in these cases, is that the priors are charged clearly as treating a vehicle and the type of vehicle as an element.
Actually, our recent case of Dunn says it doesn't have to.
Which, I'm
State
sorry.
The Dunn case, you're aware of that
Yes.
changed the what made a
Correct.
charging
Jurisdiction.
document jurisdictional or not jurisdictional, and it actually
Correct.
made the statement that not all elements have to be in there,
Correct. The
but you
jurisdiction.
have to state facts that from which you can tell if a crime has been committed.
And fair enough. I guess if that's the avenue that we want to go down, well, those facts have to encompass the elements. But what I'm saying here, these cases all arose pre-Dunn, and what we're looking at is how it's charged to inform the conclusion of whether or not it is an element or whether or not it is simply a factual allegation. And the state's position, and I think it is supported here, is that if you do that in these cases, that what you'll see is the city of Wichita consistently treated these things as an element.
Is that fair for us to do? I mean, I know we have these 3 cases and a 4th case on our non-argument docket that give us a comparison. But and as you say, that then gives us some insight as to how Wichita is charging it. But can we really look at that universe? Don't we just have to look at what we can discern from one case? And from one case, how can we tell that they're not charging a fact versus an element?
I think that's, I suppose that's a record that could have been made, I guess, clearer at the district court. But again, I don't think that that's necessary because, no, I take that back. It's not necessary because what you're looking at is, could it end up in a narrow result? Yes. Could that result then be later changed? Sure. But all I'm asking this court to do is to apply the rules that Mathis tells us. And it tells us it's okay to take a peek, to try to discern whether or not it's a factual allegation or an elemental allegation. And that's all I'm asking this court to do. I see I have 3 minutes left. I don't think I requested rebuttal at the beginning, Your Honor. If I could have 3 minutes for rebuttal, I would yield at this time unless there are any further questions.
See no further questions. We'll see you for your 3 minutes on rebuttal.
Thank you.
May it please the court, Ryan Gearing for Mr. Schrader. Obviously, as counsel stated, this is a very similar issue to the last case that we just addressed. It's a little bit different in that the statute that we're talking about, which makes the prior DUI conviction a person felony for sentencing purposes, the language is slightly different. It says that you have to be convicted for the act. And so what we need to look at is what does KSA 8-1567 prohibit? And when you boil it down, it prohibits driving a motor vehicle under the influence. And I think everybody agrees and everybody knows that, again, the Wichita Municipal Ordinance prohibits more conduct than the state law prohibits. You can get a DUI. At the time this was all going on, of course, they've changed it. But you could get a DUI on a bicycle or any other human-powered element or anything like
Counsel,
that.
as we've discussed quite a bit this morning, the plain language of the statute, and I think I understand your argument, but it seems to me you have to get past the plain language of the statute.
Right.
So how do we do that? What's the analytical path to make that clear that first hurdle that gets you into all of your constitutional arguments?
Well, my argument is that it's not the same acts. There's more acts. It's not the same acts.
I understand that, but again, that's not just reading the words in the statute. I mean, the very first question in the previous case, I think Justice Johnson asked, isn't it true that the ordinance does prohibit the acts? And I think you rightly said yes.
Well, I agree with that, Your Honor. All the acts that are prohibited by the state law are also prohibited.
And so
by-
that's the problem. I mean, and it may not be a fatal problem, but that's what I'm asking. How do you get past that? There
Well,
has to
because
be-
I think that what's intended by that, and again,
So how do we
to
get
the Hackett
to-
opinion, is that we don't want to be punishing people for doing. And I think it was an excellent analogy. But what's going to stop the city or whoever from putting everything under the sun into their DUI ordinance, and everybody's going to have a DUI conviction for state sentencing purposes, no matter what they did? And I think that this court was right in the Hackett opinion when it talked about we want to punish people, or people. The punishment needs to be for people who have committed these acts that are against the state law. The stuff in the municipal ordinance isn't. And that's why I think, like I said, and again, I understand that none of these other cases are binding on this court, but all of these other cases have come to the same conclusion. There's, and I don't have the names of all of them, but they're listed in the briefs. There's all these Court of Appeals cases where they're coming back and keep coming back and saying, if your ordinance of conviction from the municipal court or other state or whatever is broader, it doesn't prohibit the acts that are prohibited by 8-1567. And there's all kinds of different ways to get there. Some of them were situations where the intoxication standard was just under the influence, which obviously is a lower standard than being under the influence to the extent that you can't safely operate a vehicle like we are here in Kansas, or is over 0.08 legal limit, but with no time frame, which is also different than in Kansas.
It sounds like, and I'm sorry to interrupt, I'm trying to zero in on what tool of legal analysis we would use to get past the plain language. And it sounds like you're basically making an absurd results argument. Like, if this plain language were to be imposed in sort of a dictionary way, it would just be absurd.
Right, I agree with that, Your
Okay.
Honor. Yes.
Literally, too, if it's imposed literally, absurd results, or, I mean, there's really only two ways out of plain language, and are pretty much two ways out. And absurd results is on one end, and ambiguity's on the other.
I appreciate that, Your Honor. When you really boil this down, the problem is, I'm sorry to keep coming back to the same thing, but we've got these acts that are not prohibited. And you can't tell by looking. Let's say we've got one person who's convicted of DUI in Wichita that was riding a bicycle, and one person who's convicted of DUI in the city of Wichita who was driving a Ford Ranger or whatever. When you look at their convictions, in the eyes of law, they're the same. It's the same statute. It's the same exact conviction. And I was thinking more about your question that you asked me in the last case, Your Honor, about the prior conviction sometimes counting and sometimes not. And like I said, I was thinking about that some more. And say we've got two people. One guy has a prior on a bicycle, and one guy's got a prior from a car. Have both picked up a new case in the district court and are charged with second offense DUIs. There's no way to tell what happened in the prior cases without delving into the facts. And under the Hackett opinion, I think it was pretty clear that this court determined that DUIs on a bicycle wouldn't be prior convictions. So we've got a conviction for the exact same ordinance at that point, and this person's is going to count, and this person's isn't going to count, just based on factually what happened in that case. And I think that's the problem, is we can't be getting into these facts. I don't think there's a mechanism that allows the court to do that. And again, even if there was, I'm not sure that it matters, because as the same was in the last case, Mr. Schrader had pled no contest in the municipal court. And we're going to be back to making a finding of fact that was never proven to a jury by a reasonable doubt, and it wasn't ever admitted by Mr. Schrader. And since it's changing his criminal history, it's changing both the minimum and maximum sentences that he's facing in this case, which I think runs afoul of both Apprendi and Aline. I would like to address again, I know Mr. Gillette keeps coming back to this peek, that he's arguing that the court can take a peek at the record documents or whatever to determine whether these are options within a means or elements or what are they. And I just don't think that in a case like this that the court is allowed to do that. Mathis is pretty clear in the first sentence of the passage he's talking about that only if state law isn't already clear on this is that something that we're even going to consider doing. And again, I think in the Brown case, this court has recognized this. There's elements and there's options within those elements. There's various factual ways to commit an element. And under the municipal ordinance, the only element is vehicle. You operate or attempt to operate a vehicle while under the influence, one of the various, and there's several subsections, but it's just the different intoxication standards and whether it's drugs or alcohol. So again, whether it's a bicycle or a motorcycle or a car, those are not elements. Those are all the ways that you can satisfy the element vehicle under that ordinance. I'm not sure, Your Honors. I know that we just addressed a very similar issue in the last case. Do you want me to go through the Descamps and Mathis argument for purposes of this case also, or?
I need you to circle back on this particular statute on counting prior felonies and manslaughter, involuntary manslaughter. Because I keep staring at it, and Mr. Gillette's starting to woo me over to his side of the deal. With that, I can apply, here's my problem. I can apply this statute, 216811, without looking at any facts in your case. I can say I've got the conviction, now I'm trying to figure out what priors to add to the history and all that. Mm-hmm. And I can look at this ordinance and know that it prohibits any act described in that statute. I only have to look at the ordinance and the statute.
Well,
and so why isn't, that doesn't violate Apprendi, that doesn't violate anything. I can look at statutes all day and not do that. So why isn't that good enough? This is back to the plain language argument, I know, and I'm just restating it. But why, I'm not sure I understand why I have to get into any facts, which is his argument.
I just want to make sure we're talking about the same thing, Your Honor, because that statute's been amended, and I'm not sure I got it changed in my brief again. But at the time that this happened, the statute said it was prohibited the act.
Any act, which prohibits any act described in the statute defining DUI shall count as one-person felony for criminal history purposes. I think I got the right language in front of me here. But why can't I just look at that and look at the ordinance and go, that ordinance does in fact prohibit any act described in the state statute, and I'm done.
I guess my answer to that would be, I think when I'm reading that, and what I'm reading, and hopefully this is in here correctly, is that conviction in lieu of conviction or diversion in lieu of criminal prosecution or juvenile adjudication for an act described in 8-1567. Is that where you're getting that from, Your Honor? Well, I guess what I would argue then is under the municipal code, you can be convicted for an act that's not described in the state law.
So what?
They're both DUIs.
That gets back to where we were half an hour ago. So what? I can look at this statute and look at the ordinance and answer the question that the statute asked me to answer for purposes of sentencing.
I guess I don't understand how you're getting there, Your Honor.
Okay.
I don't see that the same way, and maybe I'm Dan. I don't see it. The way I look at it is we've got a conviction for an act described in KSA 8-1567, which I don't think in this case we can get to without fact finding to see whether that would be an act that was described in 8-1567, or under subsection B, violation of an ordinance which prohibits the act described in 8-1567. Like I said, the act, to me, the act in 8-1567 is driving a motor vehicle under the influence. That's the act that 8-1567 describes in various different ways. But again, the city code is broader, and there's stuff included within there that wouldn't. So you're not going to know whether it's something that would have been prohibited by 8-1567 without making a finding of fact as to what exactly happened factually in that case. If there are no other questions, I don't have anything further, Your Honor.
Counsel, you had asked us before Justice Biles' question if we wanted you to
Oh,
proceed.
yes.
That's up to you.
Okay.
This is your time. If you think it helps your case, proceed. If you think it doesn't, you've already said it, then that will end
Well,
things.
it would be the same argument as the last case, and I didn't know if Your Honor wanted to hear the same thing again.
It's up to you. This is your time.
Okay. I guess briefly, and I will go through it again just to make sure that I've covered everything. Again, when we're talking about the analysis for desk camps and Dickey and Mathis and the line of cases that describes what courts are allowed to do at sentencing, again, although the municipal ordinance for DUI appears to be divisible, which would allow the modified categorical approach, under the second step of that analysis, since the definition of vehicle is where we go astray, that's where the difference is, the definition of vehicle. And that definition is applied throughout the entire rest of that ordinance. So we never get to a situation where any of the subsections, and that brings me to something else I wanted to discuss. And again, I keep going back to these Court of Appeals opinions, but the Butler, State versus Butler, that's exactly what the court was talking about in that case. And they got this, in my opinion, they understood it. And came back and basically said it was a case with a Texas prior conviction. And they said the Texas statute prohibits driving at .08 within 3 hours of operation. That is the same as Kansas law, and that would count as a prior conviction. But it also prohibits this other stuff, which is not prohibited by the state statute. And what they were saying is, show us that he was convicted under that subsection that prohibited the .08 within 3 hours, and that's a prior conviction. And in that case, for whatever reason, the state couldn't do that, and they deemed it wasn't a prior conviction. We think that is the same analysis, the correct analysis to apply here. But the bottom line is, I don't think we ever get to the modified categorical approach, because none of the elements, none of the subsections of the municipal ordinance prohibit the same acts as 8-1567 does. They just don't. And again, even if we got to that point, our position would be that it doesn't matter, because we would still have a finding of fact, which increases the penalties classification, which, given the no contest plea, has never been proven to a jury or admitted by the defendant in this case. So, if there are no further questions, I'll yield.
I see no further questions. Thank you, counsel.
Thank you.
Just a few points to hit in my rebuttal here. The first being the question of plain language and how do we get beyond that. The state's position is that the defendant's only way to get beyond that is to have this court read in the word only that's not existent in the statute. And this court cannot read language into the statute, and therefore we believe that the plain language argument should prevail in the instant case. As for the assertion that I'm arguing for a peak, I want to be clear. I'm not arguing for a peak. The United States Supreme Court tells us you can peak. You should peak if it's not clear. And you should do it for the sole and limited purpose of determining whether or not what was alleged was an element. And
If this was not this case, it was a case where we were just trying to decide whether vehicle was an element versus a potential alternative means, What would the state's position be?
Can I ask for some clarification, because
Yeah.
different elements and alternative means are the same thing?
Okay, all right. So if that's what we're asking, an element or an alternative means, that's what we were trying to figure out.
Okay.
Let's say he came up here and said, well, there wasn't proof. They charged it and there wasn't proof of one of the alternative means, and therefore I've got an insufficient evidence problem. There's a super sufficiency requirement and I get to go home. Would the state be calling this a fact, an option within a means? I mean, what are we really looking at here? When we look at that statute, isn't vehicle an element of the crime?
I believe that vehicle, and under the facts of this case, or under the
That's the
laws-
problem.
No.
Do we need
yeah.
to get to the facts? That's what I'm trying to ask you. I'm trying to get you out of this, oh dear, I'm going to have to step in constitutional water situation, and just put you in a case where we're just trying to look at that ordinance and say, is this an element of the crime?
Right.
Vehicle is certainly an element of the crime, isn't it?
I mean, I think that operating a vehicle is an element of the crime. Yes. Now the question becomes that
Then you
that
have
doesn't
to
end.
look at the definition,
Yes.
right?
And then you can, then from there we have to determine whether or not the type of vehicle was also an element, or whether it was merely a factual allegation, i.e. an option within a means. Here, when we engage in that analysis, all indications are that this is an element. And I would return...
Because they charge it that way. Because Wichita's chosen to charge these crimes stating what type of vehicle the person was in.
That's part of it.
That's
Going
the
back-
peak, right?
That's the peak part.
Yeah.
The first part is Hackett. And this court decided Hackett after Apprendi and was able to discern and clearly state that there are differences here. You have the human-operated vehicles and then vehicles that meet the definition of state statute. This court was able to make that determination once, subsequent to Apprendi. I don't think that I'm asking for anything beyond that. Follow Hackett, follow Mathis, and we're fine. I see that I'm out of time. If I could just make one final statement, Your Honor. I wanted to address just very briefly the Butler case that opposing counsel mentioned, simply just because we haven't talked about many of these cases specifically. But the Butler case is absolutely distinguishable because in that instance, there was no viable way to determine whether the Texas statute, which prohibited DUI as, quote, under the influence of alcohol, or, quote, not having the normal use of mental or physical facilities due to alcohol, prohibited the same acts. There's absolutely no way that you can apply Mathis to that language and reach the conclusion that the Texas law prohibited the same acts. It might have, but we can't tell there. Here, you can, and that's the difference. If there are no further questions, I will be back in a moment.
Thank you, counsel.
Thank you.
Once again, we thank all counsel for their arguments. And at this